Hello everyone and welcome to the 6th episode of Vidhi's Legal Capsule. Prompted by certain recent judicial pronouncements, today we'll be talking about a rather peculiar and extraordinary power that the Supreme Court holds under the Constitution of India. About a fortnight ago, A.G. Perarivalan, one of the 7 convicts in the Rajiv Gandhi assassination case, was released after having spent 32 years in prison. His release came through an order of the Supreme Court, where the Supreme Court took into account the prolonged period of incarceration that Perarivalan had gone through. What is noteworthy in this particular order of the Supreme Court is the fact that the governor, as a constitutional functionary, is the one who has the power to remit or either reduce Perarivalan's sentence as mandated by the Constitution. However, the Supreme Court took it upon itself to order Perarivalan's release, particularly noting the fact that he had spent close to 3 decades in prison.
Another example, early in May, there was an instance in which the Supreme Court upheld the validity, the legality of some 90,000 tax reassessment notices that the Income Tax Department had issued. And the funny thing is that these reassessment notices were issued by the Income Tax Department on the basis of powers, using these powers under provisions that were not in the Income Tax Act anymore. What had happened is that Parliament had amended those powers, it had amended those provisions, and so now there were new powers that were in place. And yet the officers of the Income Tax Department had used the old powers at a time when it didn't have those powers anymore. So ordinarily, what should have happened? The court should have struck down these notices, saying that you should have followed the new procedures, you should have followed the new powers after the amendment by Parliament. But the Supreme Court instead upheld the validity of these notices, saying that there had been a bona fide mistake by the department and that if this mistake wasn't allowed for, the revenue, the collection of revenue would suffer. Basically, public exchequer would suffer and less money would be collected under tax.
What is common to the Perarivalan order and the income tax matter, and why are we talking about both of these in the same conversation? What's common to both these orders by the Supreme Court is that the Supreme Court here, in both these cases, acted expressly in conflict with express legal provisions. Also, both of these orders came under the Supreme Court's exercise of its power under Article 142 of the Constitution, which is an extraordinary power given to it. Briefly, what does Article 142 say? Article 142 says that the Supreme Court, in the exercise of its jurisdiction, can pass a decree or an order in a matter where it feels it is necessary for it to do so for doing complete justice in a cause or matter which is pending before it, and any such decree or the order that the Supreme Court passes is enforceable throughout the territory of India. Now, as I mentioned, it's an extraordinary power of the Supreme Court and unique in several respects. How is the Supreme Court's power rather unique?
Yeah, like as you see from the language of this provision, it says that the court is allowed to do whatever is necessary to ensure that there is complete justice in a case. If you see this language, then it's very different from every other provision that is there, empowering courts to do things. Courts ordinarily do justice how? They do justice by applying rules in laws or rules and provisions, explicit language in the Constitution to cases and doing justice by applying those rules. They do this in a sense, for example, by correcting wrongs, by ensuring that if somebody's rights have been violated, justice is done in the sense of corrective justice. There is a correction of that wrong. They don't do it in other ways. For example, when there is distributive justice, when there is justice that is done by ensuring that advantages, opportunities, or some goods are distributed fairly between different classes in society. These are often questions that are in the nature of policy that the government engages in. But this is also a question of a certain kind of justice. Now, what kind of justice does Article 142 talk about? There isn't real clarity in the provision itself about what it means when it says justice. And that's what makes it extraordinary. We do not have clarity, and there is no guidance for the courts about how they should do justice using Article 142.
Now, in the absence of any express clarity under the provision itself about what justice is being referred to, perhaps it would be useful to refer to certain examples where the Supreme Court has deemed fit to intervene under Article 142. One of the most prominent examples and one of the most popular one that is known to many people is the Supreme Court's intervention under Article 142 in the case of Vishakha versus State of Rajasthan. And this particular use dates back to 1997 when, as people would know, there was no parliamentary legislation on prevention of sexual harassment at the workplace against women. The Supreme Court, as we know, issued guidelines to employers as well as responsible persons on how they could prevent or they could address complaints of sexual harassment of women at their workplaces. One of the other instances which people may or may not know about dates back to sometime last year when the Supreme Court gave a timely boost to state election commissions. Now, state election commissions are institutions which are tasked with supervising elections to bodies at the local level, panchayats and municipalities. In this particular case, the Supreme Court was prompted by a development from Goa where the law secretary of the government was appointed as the state election commissioner. The law secretary, we must bear in mind, is a servant or is an official of the government, of the state government. Now the Supreme Court intervened and said that the state election commissioner should remain completely independent from the state government, and appointing a law secretary who's obviously beholden or duty bound to the state government essentially compromises with the independence of the state election commission, which obviously makes a mockery of the constitutional scheme as well.
Yeah, there are examples like this, but on the other hand, there are slightly different examples. For instance, the Supreme Court also cancelled the allocation of coal block licenses some years ago, which are basically licenses given to mining companies to mine coal. Now, these companies had gotten these licenses according to a certain procedure, but it was found that this procedure could have been better. There could have been many improvements upon it. So, even though there was no specific finding that any of these companies had done something wrong in getting that license, that is, they'd done anything actually corrupt, though there was no such finding, the Supreme Court nonetheless cancelled the allocations. This caused considerable implications for economic implications. The consequences were to the mining industry itself, the mining sector, and it was also to the financial sector that was financing these coal mining companies. Similarly, the Supreme Court has also used this extraordinary power under Article 142 to grant divorces. And it has granted these divorces not according to ordinary divorce law in India, but it has granted irregular divorces, saying that there has been breakdown in relations between two parties. In such an instance, there aren't really any high constitutional principles or significant constitutional rights and values that are at play. But nonetheless, because it finds that there is something wrong with allowing for a divorce, not allowing for a divorce in a particular situation, the Supreme Court has intervened. What you will find by looking at these examples now is that it will divide a number of people. Some people would say that in some of these situations, the Supreme Court was right to intervene, that applying rules mechanically and formalistically would actually result in more injustice. On the other hand, you will find that in some instances, the Supreme Court did not need to do what it did. It did not need to intervene. There would have been other options available, and the stakes were simply not as high. So, what is one supposed to do in this situation? There has to be some way in which the Supreme Court is better able to find out when it should intervene.
Now, the Supreme Court in the past has tried to develop certain principles on applying Article 142. However, there's been considerable back and forth and definitely inconsistency on what sort of principles these are. Now, while we await more solidified principles on how the power under Article 142 should be used, perhaps a twin test on when an intervention under Article 142 may be justified would be a little useful on how we can go forward. What can this twin test look like, or what considerations should this twin test take into account? Number one, the Supreme Court, while intervening in a particular matter under Article 142, should consider if any significant injustice would take place were the Supreme Court not to intervene in such a matter. Would significant constitutional rights or principles stand violated if the Supreme Court did not intervene in a particular matter under Article 142? So while on the one hand, a case where somebody like A.J. Perarivalan or any other convict or any other under trial has been in prison for several years at a go, possibly an intervention under Article 142 would be merited.
For liberty.
Exactly, for a very compelling concern of liberty. However, in a case like that of irretrievable breakdown of marriages,
yes,
where the Supreme Court has taken upon itself to grant divorces, perhaps the stakes may not be as high and the Supreme Court's intervention may not be merited.
That's one principle.
Yes. The second principle in this regard could be on the consideration of necessity. Is it completely and definitely absolutely necessary for the Supreme Court to intervene in a particular matter, possibly in cases where any other organ of the government may not be either willing to intervene or may not be suited to intervene? Now we know definitely that the Parliament in several instances is obviously equipped with far more resources and far more evidence to intervene in a particular matter, while the Supreme Court may not be suitably or similarly equipped. For instance, let's consider the matter of the issuance of reassessment tax notices, as was just spoken about. Possibly, a retrospective tax legislation passed by Parliament would have been a more suitable, a more beneficial way of addressing this particular concern, which would not have unintended consequences as a Supreme Court's order might have. So two principles for exercise of power under Article 142 might be necessary to look at. One is that of significant injustice were the Supreme Court to not intervene, and the second is that of necessity of the Supreme Court's intervention in a particular matter.
So a provision which has no guidance at all, provision which simply says necessary for doing complete justice, can only be applied with a beneficial outcome, with beneficial consequences, if the Supreme Court comes up with certain better, more sound principles on the basis of which, sound tests on the basis of which it can decide when its intervention is necessary. Otherwise, it will just be shooting arrows in the dark.
Thank you very much for tuning in. We hope this particular legal capsule on Article 142 of the Constitution, as we just said, a rather extraordinary power of the Supreme Court. We hope this was useful. Thank you so much.
Please join us next time.